Okay, we're back. We're back on the record in the matter of the state of Georgia versus several individuals in 22 SC 183572. Go ahead and take roll at this point in time. All right, Khalif Adams. All right, good morning, madam. Durante Bibi. All right, good morning. All right, good morning, gentlemen. All right, Damone Blaylock.
Good morning, Your Honor. Justin Hill. We're ready.
Good morning. Good morning, Mr. Williams and Mr. Steele, Mr. Adams. All right, good morning, Mr. Jimenez and Mr. Dorsey.
Good morning, Your Honor.
Good morning, Mr. Johnson and Mr. Eppinger. Good morning, Mr. Farley and Mr. Menendez.
Good morning, Your Honor.
Good morning. Mr. Farley, raise your hand for me, please. Thank you, sir. Just want to make sure. All right, Mr. Fleetwood. Good morning, sir. Mr. Garlington. Good morning, sir. Mr. Matthews, good morning. Good morning, Mr. Huey. Ms. Haggerty, good morning, madam, and good morning, Mr. Kendrick. Denise McMullen. Good morning. All right, Ms. Bernard.
Good morning, Judge.
All right. Mr. Myrick. Raise your hand, sir.
He's an N606.
All right, thank you. I see him. Okay, all right. Mr. Harvey, good morning.
Good morning, Judge. And I see Mr. Nichols. He is in booth 514. Thank you.
Thank you, sir. All right, Mr. Williams, good morning.
Good morning, Your Honor.
And good morning, Mr. Ryan. Ms. Gladden, good morning, madam.
Good morning, Judge.
Good morning, Mr. Stevens. Good morning, Mr. Botts. Good morning, Mr. Sharp.
Good morning, Judge.
Good morning, Mr. Stillwell. Where's Mr. Stillwell? Let's see. Okay, oh, he's I'm on that monitor. All right. Okay, all right. Okay, I got you. I'm sorry. Did I? I sure did. Thank you. Ms. Fagan, good morning, madam.
Good morning, Judge.
Good morning, Mr. Mender. Okay, anybody I miss? Let's see. No, I don't think so. I think we got everybody. All right. First one is just general health. As you can see, we have a high positivity rate on COVID, the flu, and RSV. So for those of you who are so inclined, please mask up, please wash your hands, please go ahead and use hand sanitizer and do all the things necessary to keep yourselves safe, and in doing so, you keep the rest of us safe. So if you could please do that. We've had a lot of the walking wounded, so to speak, as a result of many things that are going around. So I just tell everybody just to be mindful of that as we kind of proceed forward. Okay, the next thing is, as we're about to go into trial next week and set up for trial, more will follow on the configuration of the 1C and 1D for those who are still remaining to go to trial at some point. So more to follow on that. And I think today's order of march, we're going to take up the motions to sever the medical examiner, Dr. Dunbar, and talk about some of the issues of the other folks of severance. So, Ms. Rosenwasser, is Ms. Hilton coming over at some point in time today as well?
Yes, and I can get her here after course of
I believe she's going to put on the record which defendants have been offered negotiations and the rejection of those negotiations, so that those can be made a part of the record.
I will reach out to her right now.
All right, thank you very much, madam. If you do that, we can do that at some point in time and let that be known, okay? All right, so Mr. Shard, are you ready to argue? Mr. Harvey, are you ready to argue your motions, gentlemen?
Yes, Judge.
All right, well, age before beauty, Mr. Shard, so we'll let Mr. Harvey go first.
Well,
That's the way I see it, Judge.
I resent both of those remarks. Judge, primarily, we asked yesterday if we could argue the motions to sever count 65. And count 65 in the indictment with regard to Mr. Nichols, and it's the same situation as to Mr. Stillwell in count 64. First, count 65 is a standalone count, number one. It's a standalone count that charges an offense on March 17th of 2022, which is a date that is different from the dates alleged in the overriding conspiracy and the dates alleged in any other substantive counts. So, number one, it is a separate standalone offense on a date different than any other counts in the indictment. As such, we filed a specific motion to sever that count and to bifurcate that count from the trial of this particular case. Since it's a separate case, there's no allegation that the weapon that the state alleges that Mr. Nichols possessed on March 17th of 2022 had anything to do with any of the substantive offenses or the conspiracy, so it's unconnected to the other charges in the indictment. Since it is unconnected to the other charges in the indictment, it should be severed. The only reason that it is in the indictment is because it is the same or similar offense to what he has been charged with in the indictment. Judge, there are a series of Georgia cases that talk about, and Georgia law requires that when an offense is joined solely because it's the same or similar to other offenses, the defendant has an absolute right to severance of that count. So our first position is the only reason that this count is joined in the indictment is because it is the same or similar to other counts in the indictment. because it is a possession of a firearm by a convicted felon. That's the only similarity. And again, I want to make sure that the court understands there's no connection between the offense in count 65 and the other substantive offenses alleged in the indictment. So number one, it's joined solely because it's a similar offense, and therefore we have an absolute right to have it severed. If the state might make an allegation that it is connected, I don't know how it's connected, and I've seen nothing substantively to say that it is connected. And again, there are a series of cases that suggest that the admission of evidence which shows the commission of another crime is not automatically admitted solely on the basis that it is the same or similar, or that it is connected incident to the accused arrest. Now, the state may also argue that this was a circumstance surrounding the arrest of Mr. Nichols, but that doesn't make it admissible either. Starting with Benford versus the state at 272 Georgia 348, and that was way back at the beginning of this century, in the year 2000. The court said, the Georgia Supreme Court said, this court has indicated the admission of evidence which shows the commission of another crime may not automatically be admitted solely on the basis that the evidence was incident to the accused's arrest. Where the evidence is wholly unrelated to the charged crime, the arrest is remote in time from the charged crime, and the evidence is not otherwise shown to be relevant. So that's the starting point, at least, for Mr. Nichols' argument. Secondly, Mims versus the state at 304 Georgia 851. And in Mims, there was a theft offense and a murder offense. And the Georgia Supreme Court said there is no argument, much less a showing, that the theft offense and the murder-related charges were parts of a single scheme or plan, or that the offenses were of a similar character. Here, the only thing is that the offenses are of a similar character. And the court went on to say that the separate offense was not admissible because the evidence of the theft was not so intertwined with the evidence of the murder such that it would not be possible to present evidence of one without the other. The joinder of the offenses was not authorized. Citing Harrell versus the state, Harrell, 297 Georgia at 891. It's clear that the state can present its evidence against Mr. Nichols, if it has any, without being able to show, without the necessity to show the March 17th arrest and alleged possession of a firearm. So they are not so intertwined such that it would be not possible to present evidence of one without the other. That's Mims versus the state. Most recently, Judge, you know, the Georgia Supreme Court reversed the hot car case from Cobb County, and that, of course, is Harris versus the state at 314 Georgia 238. And in Harris, the court reversed in part because the trial court abused its discretion by denying appellant's motion to sever, citing Harrell again, Mims again, and Booker versus the state at 231 Georgia 598, and saying essentially, not essentially, is the quote from Booker, where the separate crime did not arise out of the same conduct, did not involve the same victims or witnesses, and the evidence of one is not admissible in the trial of the other, the judgment of the trial court overruling the motion to sever was error and constituted an abuse of discretion. Federal courts, Judge, have said the same thing. In United States versus Holloway at 1 Fed 3rd 307, there was a robbery and a one count of felon in possession, and the felon in possession was at the arrest, and there was a series of robberies, and because there was no connection to the gun at the arrest to the series of robberies, then it was error to try them together, and that's Holloway 1 Fed 3rd 307. That's a Fifth Circuit case. Also, Hawkins versus the United States versus Hawkins 776 Fed 3rd 200. That's a Fourth Circuit case. There was a carjacking and a felon in possession some days later, and the gun was not related to the carjacking charges, and therefore it was error to try them together. That's Hawkins 776 Fed 3rd 200. Judge, again, other than the fact of it's a similar offense to some of the underlying predicates, but a separate, standalone, unconnected offense, severance is warranted for count 65. And I'll let, apparently, my younger and better-looking compatriot follow up with anything he wants to say.
Thank you, Mr. Harvey. All right, Mr. Short.
I appreciate Mr. Harvey handing the baton to the younger and better looking part of this team. I would like to adopt all of Mr. Harvey's arguments and to supplement, I have another case that factually in some ways is similar to this case. It's Saxton v. State, SAXTON, 300 Georgia Appeals 535. It's a 2009 case, and it's Mr. Saxton was arrested away from the scene on a murder warrant. During his arrest, a 9mm handgun was found on his waistband, which was not related to the alleged murder. And the appellate court granted a new trial in that case based on the admittance of the circumstances of the arrest, as well as his possession of the gun after the arrest. In addition, Your Honor, I think there's a tendency to think of this issue as a severance of the gun case to ensure that my client, Mr. Stillwell, and Mr. Nichols receive a fair trial on the murder. In my client's case, 2 murders. And I'm going to get to that in a second. But the other way to look at it is we also have to ensure that both gentlemen receive a fair trial on the gun case, on that count. I'm going to bring a case to the court's attention, Mims, M-I-M-S, v. State, 304 Georgia 851. That's a 2019 case. Miss Mims allegedly stole a car in Detroit, drove it to Atlanta. She allegedly committed a murder in Atlanta. She's arrested, charged on the same indictment, theft by receiving and murder, because she's caught in the car at the time of her arrest. it was the Supreme Court of Georgia found that the trial counsel was deficient for failing to move to sever the theft count from the murder. There was no argument that the theft offense and the murder were related. So there was no factual connection between those two things. There was, and there was really no reason to bring the fact that Miss Mims was in a stolen car into the murder case, and there was no reason to bring the fact that Miss Mims was accused of murder into the theft case. Miss Mims was not, because there was overwhelming evidence of guilt for the murder, she was not given a new trial on ineffective assistance grounds for the murder, but she was for the theft charge. And the court noted that the jury's knowledge and understanding and evidence, exposure to evidence that she was involved in a particularly gruesome murder, severely prejudiced her in the theft case, the theft aspect of the indictment. And, Judge, I'm not thrilled that Mr. Stillwell is on this indictment facing two separate murder charges, and I'm going to address that in a second. But I do plan on walking him out of the courtroom on these murder charges. But I'm also concerned about this gun charge. And we want a fair trial, and we want due process, and we want a jury that is not exposed to overly prejudicial evidence to consider that gun charge as well, because that carries time, significant amount of time, and we want a fair trial on that count. And so we're going to rely on the Mims case as well to ensure, hopefully, that we receive relief from the court and a severance on that basis as well. I'll also point out before I switch to the murder cases, that in anticipation of the state's argument, to the extent that they argue that the circumstances of an arrest and possession of a gun in and of itself is relevant somehow. Any cases that they cite, to my knowledge, are going to be older cases before we switched over to this new evidence code. And that argument really relies on propensity. The idea that, the fact that these individuals are proven to be gun-toting individuals by the circumstances of the arrest with an unrelated handgun somehow is relevant in this case. And for it to be deemed relevant at all, it would really have to hook on that, would have to be the argument of propensity, which has been theoretically taken out of the purview of what we consider under the new evidence code. So I just wanted to add that as well, to keep that in mind, that anything that relies on propensity, not a good reason to let the circumstances of the murder in. I'm a little bit, Mr. Stillwell is in a different situation than Mr. Nichols in one regard, and that is that we have two murder counts and on this indictment. And so I asked for, Mr. Stillwell asked for the same relief as Mr. Nichols in regards to counts, I believe, 64 and 65, respectively, for each defendant. In addition, I asked for additional relief relief in my motion, which was severance of the murders. We obviously, for obvious reasons, want separate trials for each murder case. The courts have, in courts in Georgia, I was unable to find a case in Georgia that dealt with necessarily the joinder of two separate murders, but they have acknowledged the extreme prejudice of the admission of a prior murder into a charged murder trial in the similar transactions or other acts context. And for obvious reasons, I think the prejudice is very obvious. I think it's clear that the jury, upon inspection, it's not going to be lost on the jury that Mr. Stillwell is charged with two separate murders on this indictment. I think that the logical question that the jurors are going to ask and be confronted with is, so this defendant and his attorney are trying to tell us that lightning has struck twice, and that's something that really puts us in a position where we're fighting an uphill battle, and we believe that that deprives Mr. Stillwell of his due process rights and his rights to a fair trial under the 5th, 6th, and 14th Amendments. I would draw the case, I would bring this case to the court's attention. It is Dean v. Calderon, 163 Fed 3rd, 1073. It's 9th Circuit, 1998. There, it was held that the joinder of two murders in one indictment violated due process. And just to be clear, in this case, the Bean case, the murders were 3 days apart, 10 blocks away from each other. As you recall, Your Honor, in my constitutional speedy trial argument, what we're dealing with in this case factually against Mr. Stillwell, we're talking about one alleged murder on January 10th of 2015 and another alleged murder on March 14th of 2022. So we're talking about 7 years and 2 months separating the two. There's also a difference in the strength of the evidence in this case, which was a consideration in the Bean case as well. There's a difference in the strength of the evidence in the two cases against Mr. Stillwell, which leads to the prejudice against Mr. Stillwell, especially in the weaker of the two cases. In the 2022 alleged murder of Shamol Drinks, there's really only a grainy video and a video inside a store that shows that the state's going to say shows that Mr. Stillwell was in a store nearby and pulled out of that store shortly after Mr. Drinks. There's no eyewitness testimony, no ballistics, no forensics, no direct evidence at all that ties Mr. Stillwell to that murder other than his geographic proximity at around the time of the murder, according to the state, according to the videos. The evidence in the 2015 case, you heard about in your Honor, yourself in your ruling against me in the constitutional speedy trial argument, noted the complex and thorough investigation of that case. There are witness after witness after witness that gave statements of varying degrees. There's several, I think you heard of one of them, third-party confession type witnesses So there's definitely a different quantum of evidence against Mr. Stillwell in each of these cases. And under the reasoning of the Bean case that I cited, joinder of those two cases would be constitutionally impermissible. And I'll just add also that in Bean case, they found that the jury charge that I know Your Honor is going to give, which is that the jurors should consider each and every count individually, was wholly insufficient to protect Mr. Bean's constitutional rights. So we are asking for separate trials for each of the murders, and we are asking for a separate trial for the possession of firearm count as well on behalf of Mr. Stillwell. Thank you, Judge.
All right, Mr. Floyd?
Yes, Your Honor. Thank you. Well, it'll be no surprise that the state has a fundamentally different view on these issues. These severance motions are, to a significant extent, subject to the same type of argument that we have had previously on, I think, now 8 severance motions, where we've talked about general RICO principles, we've talked about the efficiency, the presumptions that govern, et cetera. And I'm not going to repeat all of that. You've heard it all multiple times.
Guns are a little different, though. So,
And so I was going to turn to the specific variations that we have here, to the extent they aren't the same as what we've talked about before. And part of that begins fundamentally, you heard Mr. Harvey talk about how counts cannot be joined simply because they are the same or similar. Same or similar was the exact language, the exact words that he used. And he said that if that's the only reason they're joined, then there's an absolute right to severance. That may be correct in some other circumstances. The state doesn't concede that, but the fact of the matter is it walks directly into the elephant in the room, which neither motion addresses in any way, which is the presence of count 1, the RICO conspiracy count. There was no mention of that count in any of the arguments. It was simply not addressed, as though if it were ignored, it would somehow go away. Not one case cited by counsel for either movant is a RICO case. And so why does RICO change this? Well, it changes it for several reasons, but the first of which deals with the definition of pattern of racketeering activity. Because when, and I've made the point previously that a pattern is not an essential element of the conspiracy claim, but that doesn't mean it isn't relevant at all. That doesn't mean the state can't introduce evidence of it, because the actual commission of racketeering activity supports the inference of an agreement to engage in that activity. And the granddaddy case on that is United States versus Elliott, 571 F. 2nd, 880, a 1978 former Fifth Circuit case, which has subsequently, of course, when the Fifth and the 11th separated, when the 11th was created, that law became the 11th Circuit's law. The 11th Circuit has reaffirmed Elliott many, many times. So this evidence is relevant. And when you look at 1614.3, the definition section of RICO, subpart 4A, the definition of a pattern of racketeering activity, it says engaging in at least 2 acts of racketeering activity in furtherance of one or more incidents, schemes, or transactions that have the same or similar intents, results, accomplices, victims, or methods of commission, or otherwise are interrelated by distinguishing characteristics. In other words, that is exactly not the rule that the movants are relying on for severance. Here, every defendant is alleged to be an associate of YSL. When we look at these murders, and we look also at the attempted murders, which were not mentioned in the severance, motion by Mr. Stilwell. Every victim in the murders that are relevant to one or both of these move-ins was an associate of a rival gang. And so just saying these acts are unrelated doesn't make it so for the move-ins. We have gang associates killing gang associates, trying to kill gang associates. We have them getting arrested shortly after murders and attempted murders with weapons in their possession. And the charges are possession of a firearm by a convicted felon who was previously convicted of a felony involving use or possession of a firearm. In this case, counts 64 and 65, 3 days after the murder of Shimel Drinks. So these are not unrelated. They go to the question of association with the enterprise. They go to the question of knowledge of the enterprise's activities. And in each case, each of these murders and each of these attempted murders, and the count 64 and 65, the individuals we're talking about were present with other members, other associates, of YSL. None of these are one-on-one murders. None of these attempted murders are one-on-one. And the arrests in possession, Mr. Nichols and Mr. Stilwell are together at the time. That is exactly what RICO says is related, and that was designed specifically to prevent this kind of severance, where acts committed in connection with association with the RICO enterprise by persons associated with it do not get chopped up, do not get severed. And when I say chopped up, I'm not kidding. I had a little trouble counting, and if I'm wrong, I apologize. But although the math is, the exact method of severance and reason for severance is not identical between Mr. Nichols and Mr. Stilwell, if you were to grant their motions as written, they would have 4 trials, each. Okay? Because none of them says the RICO trial doesn't go forward. And none of them says the overt acts we're talking about that are also some of these counts don't come into that RICO trial. So the jury is going to hear that evidence. Even if you sever out a murder charge, even if you sever out a gun charge, it's still going to be heard as part of the conspiracy charge. So we get all the inefficiencies, but none of the supposed protections. But the motion just simply, they can't create a vacuum in which count 1 doesn't exist. And they can't create a vacuum in which count 1 and RICO don't serve the purpose they were specifically designed to serve. And I recognize that that may present additional difficulties for the defense. But that was the General Assembly's decision. And all the due process arguments that you've heard today have been made in reference to RICO. They have all failed. You've heard a number of due process arguments already in various contexts. But the fact of the matter is, Georgia RICO and federal RICO have survived every due process argument ever made against them. And that includes arguments arising out of severance motions. Again, the answer to this is RICO, and neither Mr. Stilwell nor Mr. Nichols have cited a RICO case, have cited a RICO provision, have sought to distinguish any of the grounds that apply here, or have sought to address any of the hundreds of cases that have rejected exactly the kinds of arguments we're talking about here. The idea that murders happened on different dates, have different victims, well, murders usually do have different victims if they occur on different dates. But that doesn't change anything here. In fact, that supports a RICO argument. Because part of what it is designed to address is people who commit multiple crimes over an extended period of time. That does not strengthen a severance argument. It actually weakens it. The argument that what the state is really using is a propensity argument, I take it that's meant to be 404B, gun toting, again, doesn't address the nature of the RICO pattern definition. if there is one of the organizing principles that RICO talks about, and those include the same or similar victims, we have that here. Every murder victim, every attempted murder victim, as to these two defendants, the counts we're talking about, is an associate of a rival gang. Same or similar intents kill members of associates of rival gangs. Same or similar results. They are killed or they are wounded and survive. Same methodology. Firearms are used. Not talking, none of the rival gang members are attacked in any method other than, outside of a jail, other than using a firearm. Okay? And while it may be a propensity, we have the fact, one of the ways, if you want to show that you're a member of an enterprise, is you have a person who's got a gun conviction, and the first thing they do when they get out is they acquire a gun, and they commit another crime. That is consistent with the concept of enterprise, not antithetical to it. I can go on, but I think if the court has any questions for me to address, I'd be happy to do so. But the overriding principle here, I think, is this, Your Honor. Even if you severed out the counts they're talking about, all the evidence comes in the main conspiracy trial. They haven't given you a reason why any of it doesn't, which makes severance pointless. All the inefficiencies, all the problems I've talked to you about in earlier arguments apply. You simply end up with a series of complicated trials. The severed ones for these defendants might be somewhat simpler. They might not involve all of the evidence in count as would be in a trial in count one. I don't want to misrepresent there. But there would still be a ton of evidence that comes in for context and other reasons. They would not be simple trials. And therefore, the motions for severance should be denied.
Okay.
Judge, can I have a response, a brief response here?
Okay, Mr. Harvey.
Judge, I think Mr. Floyd, while a very smart man, is a little bit disingenuous in his argument. I heard nothing, not a single thing related to how count 65 is admissible in count one. Not a single thing. All he said was, yo, Judge, RICO, everything comes in. Wrong. That is absolutely not true. Number one, this is an indictment that came down after the March events. And indeed, it was superseded on August 5th, 2022. That was well after the alleged March 17th event in count 65. I will note that while there are, 191 predicate acts in count one, count 65 is not one of them. If the state wanted to say this was part of the RICO conspiracy, they could have put it in as a predicate act. They didn't put it in as a predicate act. They didn't mention anything in count 65 that this was related to either RICO or a gang prosecution. So when we say, when Mr. Floyd says you can't take this in a vacuum, they indicted it as a separate standalone offense unrelated to the RICO enterprise, and I've heard nothing that suggested it's otherwise admissible. It hasn't been noticed under 404B. It hasn't been put in as a predicate act in the RICO conspiracy. It was indicted as a separate standalone count. And you can take nothing else. I've heard nothing else to suggest that it is just because it's indicted, it's admissible in the RICO conspiracy. So it is not part on the indictment's face. It is not part of the conspiracy that's charged. Saying it's relevant doesn't make it relevant. In fact, the cases say just the opposite. It's relevant in 403, prejudicial. as a standalone count, nor has it been indicted under or noticed as 404B. So I would suggest to the court that it is a standalone count. It should be severed. And again, I have a different argument than Mr. Sharp has on his double murder. But as far as count 65 is concerned, that should be severed. It is very easy to try the underlying case without anything to do with count 65. The underlying case can go forward without anything coming in from count 65, and it's nothing to sever as the court should count 65. So I'll leave it there.
Thank you, Mr. Harvey.
And Your Honor, briefly, may I?
Just because you said may I, go ahead.
Thank you, Judge. I adopt Mr. Harvey's arguments regarding my client, Mr. Stillwell, on count 64, and I agree with him wholeheartedly. I would just also like to point out that Attorney Floyd, pointed out to the court that part of this is Mr. Stillwell and Mr. Nichols were associating with each other on March 17th. I don't want to speak for Mr. Harvey. I am not arguing that they can't say that they were arrested on March 17th and they were together. They can still say that, but it's the presence of the gun that is wholly irrelevant and deserving of its own separate trial.
Actually, Mr. Short, if I did do that, I could just sever the count. If I was more apt to do it, I'd just sever the count, let that same jury go ahead and pass on that issue. If your client were found not guilty, of course we'd have another trial. But if your client's found guilty, I'll let the jury go ahead and just handle that one, present evidence on that.
Well, are you suggesting a bifurcation?
Yeah.
Well, no, I that's not what I'm asking for. And this is why, because it goes back to, I care about this gun charge as well. So this gun charge is a standalone count, and I don't really want this jury, after being exposed to evidence, even after they acquit my client of 2 murders, I don't want them to be the ones that determine his guilt or innocence on the gun charge. So I think it needs to be removed from the indictment wholly, and that would need to be tried. But Judge, the good news is, as Chief Judge, you could send it to someone else and we could deal with that another time. But in just turning the page briefly, regarding my arguments about the double murder, I understand Mr. Floyd's point, but, Your Honor, I still, it's all based on, well, this is the way we indicted, and so therefore it makes it okay. And I just reject the premise and the argument that the state always just gets to set the procedural rules. And the state, just because they choose to indict something a certain way, my client must accept the fact that he's tried on 2 separate murders more than 7 years apart from each other, just because the state chose to do it this way. I think that's fundamentally unfair. We believe, as the defense, that we have a right to have a seat at the table for the procedural rulemaking for the trial of my client, and we reject the fact that just because they indicted it this way, my client has to accept it. And I'll just point out that while it may have withstood separate challenges in the past, the state RICO statute doesn't trump the U.S. Constitution. And my argument for Mr. Stillwell in demanding 2 separate trials is based on the 5th, 6th, and 14th Amendments of the United States Constitution. So I'll just leave it at that. But just to be clear, we are asking for, regarding the gun charge, a separate trial, wholly separate trial.
All right, Mr. Floyd, you get the last word.
Thank you, Your Honor. Just a couple of quick points. First, as to the constitutionality issue, the constitutionality of RICO is established. It's established in this context. No constitutional challenge has been asserted here. No case has been cited. It just isn't in play. If it were, the argument wouldn't be successful. But there is one premise in Mr. Harvey's argument that is incorrect. And that is that because, and this is solely with reference to count 64 for Mr. Stillwell and count 65 for Mr. Nichols, which is the same, each charges the same offense, charges it on the same day. They were each arrested together at that time. They were, I believe, in a vehicle together, each having a weapon. But the premise of his argument is that if we have not specifically alleged something as an overt act in the indictment, that it is inadmissible at trial. That is simply not a correct premise. And the cases against that are legion. We have alleged a great deal, a great number of overt acts, but that does not bar us from introducing relevant evidence at trial, either to establish agreement or to establish any other element or to respond to any defense that's presented. I just want to make that point clear because it's simply not a correct statement of law.
Okay. All right. Okay. In terms of Mr. Harvey's motion in regards to Mr. Nichols of count 65, the court's going to deny that motion. And in terms of Mr. Shard's motion to sever count 64 as it relates to Mr. Stillwell, as well as his severance of the 2 homicides, those are also denied as well. Mr. Floyd, if you prepare a suitable order, send that, of course, to counsel before it's sent to me for signature.
Yes, Your Honor.
I greatly appreciate it. Okay. Now that that is complete, Ms. Rosenwasser, do you have our medical examiner next?
Yes, we do. We do with Dr. Stanley.
All right. Will we summon Dr. Stanley, please? Tim Stanley.
I don't know whether you want me to bring it up now. You've admitted that, you know, as a practical matter, I would. I'm sorry?
Mr. Harvey, I can hear you.
Oh, okay.
Okay.
Judge,
If you're having
well, I just,
hold on.
I wanted to say that, and maybe we can take this up later. I would, of course, object every time any evidence as to count 65 comes in the trial of the case. So,
Would you like it to be a continuing objection, sir?
yes, exactly.
Okay. That's fine. Mr.
All right,
Sharp,
thank you.
Would you like that to be a continuing objection as well as it pertains?
On behalf of Mr. Stillwell, yes, we would, Judge. Thank you.
So noted, gentlemen. All right.
Thank you.
Dr. Sim Stanley, Madam, good morning. I'm Judge Glanville. If you could please approach the witness stand. Once you get there, you'd be so kind to turn and face Deputy Talton and be sworn as a witness, please.
I do. Melissa Sims Stanley, MELISSA SIMS STANLEY.
Dr. Sims Stanley, where are you currently employed?
I'm an associate medical examiner with the Fulton County Medical Examiner's Office.
And how long have you been at that position?
I was hired full-time in July of this year. However, I did begin as a locum tenens medical examiner with Fulton County in March of 2020.
Now, what is a locum tenens?
Locum tenens simply means a contract worker. So as a locum tenens medical examiner, I was contracted to perform the duties of a medical examiner, perform autopsies, complete autopsy reports.
Okay. And where were you working before that? Were you also doing similar work before those positions in Fulton County?
Yes, I was a Central Regional Medical Examiner for the Georgia Bureau of Investigation from July of 2000 to December of 2019. I then was a local medical examiner for Houston County from February of 2020 to April of 2022, as well as my work with Fulton.
Okay, so between 2020 and 2022, you were serving 2 communities doing the medical examiner work?
Yes.
Okay. And is it fair to say you've been in the field of doing this medical examiner work for about 22 years?
Yes, ma'am.
Okay. Now, what was the training that you received to become a medical examiner?
I obtained a Bachelor of Science from Emory University, a medical degree from the Medical College of Georgia. I did an internship year in internal medicine at the Medical College of Georgia. I then completed an anatomic and clinical pathology residency and fellowship in forensic pathology at the Medical University of South Carolina.
Okay. And did each of those have something to do with what you do now at the medical examiner's office?
Yes, my training and my residency and my fellowship, yes.
Okay. And are you certified in any fields? You have board certifications?
I'm board certified in anatomic, clinical, and forensic pathology.
And what does board certified mean?
Board certified means that I successfully completed the test with the American Board of Pathology, which is the national accreditation agency or organization for my specialty.
Okay. And has any work that you've ever done been published or written down somewhere that, publication you've done personally?
My only publication was during my fellowship year in Charleston, South Carolina.
And was that related to death examinations?
Yes.
Okay. Now, are you involved in any other organizations or anything that I've missed?
I'm a member of the National Association of Medical Examiners.
Okay. And how do you keep up to date with any new developments in your field, or make sure that you're up to date on the newest science?
By reading the American Journal of Forensic Medicine and Pathology, which is a publication of the National Association of Medical Examiners, attending meetings, and also I read the New England Journal of Medicine.
Okay. Your Honor, at this point I'd like to approach the witness with what's been pre-marked as State's Exhibit 24. This is Dr. Sim Stanley's CV. I have it here in case any defense attorneys would like to view it before I approach the witness.
You may approach.
Thank you, Your Honor. Dr. Sim Stanley, could you please let me know if you recognize that document?
Yes, this is my CV.
Okay, and does there appear to be any changes, alterations, substitutions, deletions as far as it is concerned?
No, ma'am.
Your Honor, at this point, I would move to tender State's Exhibit 24 into evidence for the purposes of this hearing.
All right, hearing no objection, it's admitted.
Dr. Sim Stanley, what specific work do you do as an associate medical examiner at the Fulton County Medical Examiner's Office?
My duties are to perform postmortem examinations, complete autopsy reports in a timely manner, and then testify in court to those cases if necessary.
Have you testified previously before today?
Yes, ma'am, I have.
Do you remember about how many times you've testified as a medical examiner?
During my career, greater than 150 times.
Okay. Do you recall if you were qualified as an expert or not?
Yes, ma'am, each and every time I was.
Okay. Do you recall what subject you were qualified as an expert in?
In the specialty of forensic pathology.
Okay. And was that just in Georgia or other states? I know you mentioned South Carolina as well.
Just in Georgia.
Were any of those cases civil or just criminal?
The vast majority are criminal. However, I have testified in a small number of civil cases.
Okay. Now, I know you said that you complete autopsies, determine cause of death, that sort of thing with your work. How were you trained specifically to be able to do that?
My training was during my pathology residency, but mainly during my year of fellowship in forensic pathology.
And were you trained in certain techniques for how to do autopsies and how to, basically how to determine cause of death and generally conduct autopsies?
Yes, I was trained on how to competently perform medical, legal, or forensic autopsies during my training and with my studies.
Okay. And you know, are those training methods and methodologies that you used, are those published anywhere, textbooks, guidelines, somewhere that someone could read them and look them up?
There are chapters on autopsy techniques in the forensic pathology textbook by DeMayo, medical legal investigation of death by Spitz and Fisher, but also training with my attendings who were experienced in the field.
So is it fair to say that other medical examiners probably use the same procedures that you've been trained in?
Yes.
Okay. And when you said that you stayed up to date with developments in your field, are those journals that you mentioned, do they cover topics that are germane to autopsies and other work of the medical examiner?
Yes.
Okay. And to your knowledge, are the documents that are in both your textbooks and those journals, are those peer reviewed to your knowledge?
Yes.
Okay. Now, when you perform autopsies, is your work ever checked by others?
Certain cases are peer-reviewed by other medical examiners.
Okay. And are there general kind of best practices for how to conduct an autopsy?
The appropriate or best practices to perform an autopsy would be in conjunction with the knowledge and the training and experience that a medical examiner has.
Okay. And when you do autopsies, do you always follow those best practices and the methodology that you've been taught?
Yes, I do.
Okay. Did you perform an autopsy on a Shymel Drinks in this case, and that's Fulton County, did you perform an autopsy on a Mr. Shymel Drinks?
I did.
Okay. And did you create a report when you did that autopsy?
I did.
When you did that autopsy, did you follow all of those standards and procedures for the best practices to do an autopsy?
Yes, I did.
Okay. Your Honor, at this point, the state would move to qualify Dr. Sim Stanley as an expert in forensic pathology based on her training, her experience, and her qualifications in this field.
Anybody wish to applaud Dr. Sim Stanley? All right, the court will then designate Dr. Sim Stanley as an expert in the area of forensic pathology. Dr. Sim Stanley, I'm going to go ahead and excuse you at this point in time. The state or the defense will call you when we need you, okay?
Yes, sir. Thank you, Your Honor.
Thank you for your patience. All right, just give me a second. Counsel, I'm going to go ahead and take a break. I think we've got a message that Mr. Nichols wasn't feeling well, so I'm just going to pause or recess, find out what's going on with him, and then do you have your next witnesses in pocket?
Your Honor, the only other thing that I believe on the docket today is Mr. Fields' witness.
That's correct.
And, Your Honor, I do...
Is Ms. Hilton coming over?
I will ask her to come over right now, Your Honor.
That'd be wonderful. Okay. Is your witness here, sir?
You told me yesterday, have him in the afternoon, but if you let me make a phone call, I'm going to ask him to come right now.
Okay, that's fine. Okay.
Judge, can I make an inquiry? I understand. I see that Mr. Nichols, this is Bruce Harvey
You're
on
the back
behalf
door,
of Mr.
Mr.
Nichols.
Harvey.
What's that?
You're the back door. I already said I recessed. I'm going to recess to find out about him, okay?
I understand that, but what I wanted to inquire was whether he left the booth during
Mr. Harvey, Judge.
Yes, Mr. Chamberlain.
Judge Glanville, I just sent you an email concerning Mr. Nichols. So if you want to make that announcement, that's fine.
Okay. I wanted to know whether he was present for the argument.
No, Mr. Harvey. Mr. Harvey, he wasn't present for that argument. Okay. And we just got indication as to what's going on with him.
Okay, thank you. That's what I wanted to inquire about.
That's fine, sir.
Mr. Chamberlain, why don't you offline tell Mr. Harvey what's going on with Mr. Nichols, okay?
I'll call him.
Okay.
All right.
We'll call you and let you know. It's he's going to medical at this point in time, Mr. Harvey. So I'll need to talk with you about what's next steps. Okay?
Yes, sir.
All right. Thank you, sir.
All right.
All right. I'm going to be in recess, and we'll be in recess until such time. Give me about 15 minutes, okay?
Your Honor, is there any reason that we need to keep Dr. Sim Stanley here?
No.
Based on that? Okay.
No, she can be released. I said, excused her. Yes. Okay.
Good morning, gentlemen. How are you guys doing today?
How are you?
The same, you know, same old, same old. Oh, this is really the same old for me because that's just what I do. Spend my life doing, spending time in court, you know, from one case to the other. So this is literally what I do.
I'm glad we didn't lose another attorney yesterday.
What, yeah? Glad you didn't what? I'm sorry?
I'm glad we didn't lose the attorney yesterday.
Oh, I'm glad too.
That's
That was. Well, you know,
like after the judge explained why she couldn't talk to her earlier.
Right. Yeah.
You realize, oh, yeah, you're right.
You're right, yeah, I need somebody in my corner. Well, he should have known that he was just impassioned, you know, and maybe he thought it could continue or something, and that she would take him off the case. You know, there's all kinds of reasons.
So, have your client been offered a deal?
Huh?
Have you been offered a deal? Have your client?
I can't say that, but most of the people have that aren't real people.
I mean, there's something that's about to come down and say it.
Yeah, I mean, several things may happen today. You know, I'll let you know for sure. I will let you guys
Well,
know.
can you guys do anything on January 3rd?
Right now?
Because
I mean, today's the day. If it's gonna be a plea, it's gotta be
they
today.
cannot do anything on January 3rd.
I don't think they're having a court.
If the second is Monday.
Right, and then Tuesday, they would normally have it, but for some reason, the court, I don't think it starts on the before.
Today is the last day.
So today's gonna have excitement, action.
Yeah.
Who knows what the day will bring?
Yep. Be ready.
All right, ladies and gentlemen, we're back on the record at this point in time. Let's see if I can count for my parties right quick. Mr. Harvey, any updates on Mr. Nichols?
The only updates I have, Judge, is that he was feeling sick. As you know, he tested positive for COVID. He was feeling very badly. They took him. He left the cell, and they're taking him to the doctor for further evaluation. But as you can see, he is not present. I know that this is somewhat of a medical emergency. I don't think, and I think the record will reflect that he left during our argument on his motions this morning before Your Honor, so he wasn't present for those.
I'll clarify one thing. I do know that he left before Mr. Floyd's final argument, but he was there and present for up until that point in time. So yes, I would agree with you.
And Judge, I was looking at you and Mr. Floyd. I wasn't looking at Mr. Nichols, but for at least a portion of argument on his motions, he was not present, and he wasn't present for your ruling. Number two is clearly I don't believe that he will be present today and this afternoon. I certainly can't waive his presence, physical or by Zoom or otherwise, number one. Number two, I understand that motions going forward, perhaps this afternoon, deal with either the rap song lyrics, which are a part of at least count 90, Predicate Act 95 with regard to Mr. Nichols. It's an evidentiary motion, which is different than our legal argument this morning. So I don't know. I can't say that I can waive his presence for this argument, which is an evidentiary hearing.
Okay. We heard any updates in regards to Mr. Nichols, Mr. Chamberlain, from the jail?
Right now.
Is Miss Livingston on the platform? said he's home. Mr. Harvey?
Yes, Judge.
I have been informed by medical that Mr. Nichols is still awaiting treatment or to be seen by a doctor. So I'm just going to recess in place and we'll see what that particular announcement looks like. So we'll update you accordingly, okay?
Yes, sir. Thank you.
Okay, all right. For the rest of us, given it's the lunchtime hour, I'll probably just go ahead. I'm going to go ahead and recess in place, or recess, I should say. But before I go ahead and do that, Ms. Hilton, do you have anything that you wish to put on the record for purposes of offers that have been extended?
Yes.
Okay.
Your Honor, currently we have 3 offers that are extended. Sure. We have 3 offers that are extended. I do not see Ms. Fagan, Attorney Fagan, in the courtroom, so I will not do her client because I do not see her present. However, for Mr. Durante Beebe, the state has extended an offer. First, I'll tell you the charge that Mr. Beebe is charged with and his maximum exposure. Mr. Beebe is charged in count 1 of the indictment, which is conspiracy to violate the Racketeer, Influence, and Corrupt Organizations Act. He is looking at a sentence of between 5 and 20 years in custody. He's charged with count 8, which is theft by receiving stolen property, a firearm, which is a sentence between 1 and 10 years in custody. He's charged with violation of the Georgia Controlled Substance Act for the sale of marijuana, which carries a sentence of 1 to 10 years. He's charged with another count of violation of the Georgia Controlled Substance Act, possession of marijuana with intent to distribute, which also carries a sentence of 1 to 10 years. He's charged in count 11 of this he's charged with an additional count of possession of a firearm by a convicted felon, which carries a sentence of 1 to 5 years. He's charged in count 12 of this indictment with participation in criminal street gang activity, which carries a sentence of 5 to 20 years. He's charged with count 27, which is armed robbery, which for Mr. Beebe, because he is a convicted felon, is life imprisonment. And count 28, hijacking a motor vehicle in the first degree, which carries a sentence of 10 to 20 years. Mr. Beebe's maximum exposure, Your Honor, is life in custody plus 95 years. The state's recommendation, Your Honor, based on certain special conditions, is as to count 1, 20 years to serve 6 years in prison, followed by 14 years to serve on probation. We initially have agreed on count 8 to dismiss or null pros that count. Count 9 would be 5 years to serve in prison, concurrent with count 1. Count 10 would have merged with count 9. As a part of our negotiations, if accepted, we were agreed to null pros or dismiss count 11. Count 12 would have been 20 years to serve 6 years in prison, again followed by 14 years to serve on probation. That would have ran concurrent with counts 1, 9, and 11. Count 27, we would have agreed to, after certain special conditions were met, reduce the hijacking to theft by taking. And as to count 28, we would have reduced it as well we would have reduced count 27 to a robbery, and we would have reduced count 28 to a theft by taking. So the state's total offer would be, if accepted, 20 years to serve 6 years in custody. That offer ends today by close of business.
Okay.
Next is Mr. Trontavious
Hold on one second. Mr. Partridge, have you, otherwise has that offer been communicated to you and your client?
Yes, sir.
Have you explained that to your client?
Yes, sir.
Okay, all right. Just want to make sure. Okay. It's still open till the, as the state said, the close of business today, all right?
I'm still here. Thank you.
Okay. All right, who's next?
Next, Your Honor, is Mr. Trontavious Stevens. Mr. Stevens is charged with the sole count of count 1, conspiracy to violate the Racketeer, Influence, and Corrupt Organizations Act. That is a minimum of 5 years and a maximum of 20 years. The state's recommendation to count 1 is 10 years to serve 2 years commuted to time served with balance of 9 years on probation, subject to special conditions of the agreement, Your Honor. That also has been communicated to Mr. Stevens through his attorney, Attorney Gladys, and that offer is also open or closes today at the close of business, Your Honor.
Ms. Gladden, good morning, madam.
Good morning, Your Honor.
Is that offer being communicated to your client?
Yes, Judge, I wanted to point out that if the recommendation is 10 years and he was given 2 years to serve credit for time served, I think it would be about 8 years on probation.
Excuse me. Yes, I'm sorry, my apologies. It'd be 8 years.
Thank you so much. And I understand this offer to finish with the end of the day today, Judge. We are still.
Does he have any other things that are holding him in?
No, Judge.
So he would get out today?
Yes, Judge.
Okay, all right.
And Your Honor, one more thing, as it relates to Mr. Stevens, he is a Class C recidivist as well, so his maximum exposure is 20 years to serve, which would have to be served door to door.
And Your Honor, I don't believe that we've been served.
Has a recidivist notice been filed? Oh, they're telling you, what they're telling you in the most artful way, Ms. Gladden, is that's coming.
Yes, Judge.
Okay, all right. All right. Okay, I got you. I got you.
Thank you, Your Honor.
Okay, all right. Ms. Fagan had to get some medication, so I think she will be back.
We'll be back shortly, Judge.
She'll be back shortly, okay?
Yes, Your Honor, thank you.
All right, okay. Madam, we can go ahead and put that on the record when she comes back, if that's all right with you all. All right, okay.
Yes, Your Honor.
Mr. Steele, I think we're in a holding pattern at this point in time. It's going to really depend upon Mr. Nichols' availability as to whether or not we'll be able to go forward this afternoon, unfortunately. Unless you've got some other precedent I can use, but just think about it.
Well, I believe what can be done is Mr. Harvey is not able to waive his client's presence, which I understand. And under the Georgia Constitution, his client didn't acquiesce. So it would be a good issue for Mr. Harvey. But you can always recreate what occurred and then tell the gentleman later via transcript. We could redo the hearing, but I don't think we'd have to redo the hearing. But he can be told and informed. So that happens at all time at bench conferences, Your Honor, where the accused is not present, but then the accused is told later what occurred, and if they don't object that it occurred outside their presence, then it's not error. Now, if the gentleman objected to it because he wasn't here, he wasn't able to participate, talk with his lawyer, he might have had some interest in it, he might have asked his lawyer to ask some questions, then it can't be cured.
Yeah, I would agree with that. So let's just pause on that issue and let's just see where he is. Let's just see what happens with Mr. Nichols this afternoon. We'll just take it as we come. As I mentioned earlier, unfortunately, it may be that we may have to take it up before this testimony is sought to be introduced. So, all right, we're going to be in recess. Let's just we'll be in recess until about 1 o'clock, or at least until I hear something from medical. So if everyone could come back at 1 o'clock, that'd be fine. All right, we're in recess.
Yes, Judge.
Good afternoon, sir. We are back on the record. I do have an update as to your client, Mr. Nichols. I'm sure the sergeant can share with you. He did go to medical. He refused due to the length of it, but he's back in his cell, and he's otherwise exhibiting symptoms of COVID, and he looks from all objective appearances to be pretty ill. So,
okay, Judge, I'm sorry. I can't quite understand you on the Zoom with your mask on, and I apologize, but I didn't quite understand what you said.
Your client's sick.
Yes.
Okay, all right, okay.
I got that much. That's great. That's the way I like to hear it. But I can't waive his presence.
And I didn't expect you to do so, sir. And because of that, I think we're going to put a pin in this afternoon's proceedings. Mr. Steele, unfortunately, I think that we are at a point where, since this is fairly significant testimony, that I don't want to necessarily repeat it. I don't think there's any other way I can do it. So unfortunately, we'll just have to move it down the road along with some other things that we're going to probably have to do, okay? All right, unfortunately. All right. Okay, just as a matter of housekeeping, we are going to commence on Wednesday, the 4th of January. 9 o'clock, courtrooms 1C and 1D. The lawyers and their clients will be in 1C, and our overflow and other courtroom will be 1D. So report to 1C, the lawyers, and Mr. Chamberlain?
Yes, sir.
Do you have any administrative announcements about clothing or other things?
I asked all attorneys if they had clothing, please let Deputy Talden know, and they have been coordinated with him since they're right underneath the holding cell.
Okay.
1C and 1D.
So lawyers, please do not come to court on Wednesday and say my client doesn't have any clothes. I'm telling you that right now. It is your responsibility to have your clients trial ready. If you'd like them to be dressed out, that's fine. We will accommodate you, but you need to provide that clothing, and that clothing needs to be provided. What time, Deputy Talton, does it need to be provided by? When does the clothing need to be provided?
Yeah, I told them they won't bring I didn't before 7:30. I told asked them to speak for a person.
Are you here Tuesday? You here Tuesday? Tuesday. You here Tuesday? Okay, we don't start till Wednesday. All right. Tuesday is kind of an administrative day for us, so if you have clothing, my suggestion is, counsel, is you bring it in on Tuesday so that Deputy Talton can catalog it for your client, and it's there, and we don't have any delays, so that if you've got any other clothing or for your client, go ahead and bring it in on Tuesday. Come up to my chambers, courtroom 8F, chambers, and Mr. Chamberlain, we'll make sure that Deputy Talton gets it, okay? So.
Your Honor, may I ask a quick question?
Yes, Ms. Bernard. Yes, you do have to come in person.
Yes, I know. I will be.
Okay, all right.
Is it possible for Deputy Talton to confirm receipt of clothing or say who does not have clothing? Because I know I did deliver clothing. I just want to make sure.
Yes, I did clothing. Also, if you bring clothing, please label it with your client's name on it.
Yeah, if you bring clothing, please label it with your client's name on it. Just like we did when we were little. Okay? All right. Yes, Ms. Bernard, thank you very much for that very helpful suggestion. All right. Any other administrative questions, folks?
My only question, Judge, is can I check? I will check on the status of.
Yeah, it's two of us. We're disconnecting and stuff. We got a label.
Mr. Chairman, I can hear you. Put yourself on mute, please. Go ahead.
On the physical status of Mr. Nichols prior to Wednesday, I don't know what the CDC guidelines are for quarantining. I would hope that he is better and out of the quarantine process so that he can physically appear on Wednesday. That would give it a 1, 2, 3, 4, 5 days. That's at the inner limit, I think, of the quarantine. So if he's sick, still sick today. Yeah, well,
Okay.
You're welcome.
Well, I'll let the other medical professionals and others weigh in on that. Okay, but no, I do understand what you're saying, and I will go ahead and gauge accordingly. Okay.
Yes, sir. Thank you.
No problem. All right. Anybody else? Any other administrative and yes, Mr. Adams.
Yes, sir. I don't know if this falls on the administrative, and you may be getting there. You probably thought about this already, but just so we kind of have a sense, when do you anticipate we'll address issues like additional strikes, alternates, seating arrangements in the courtroom? Seating arrangements probably will do that on Wednesday, I guess. But things like that, you want to just kind of hold and we'll discuss those as we go along. I know we're just doing hardships next week, but we've been talking and thinking about things like additional strikes and so forth.
Well, yes as to all, but I think that we'll need to get through the first few days in order for us to, I think that it'll be a minute before we start getting that, because we'll need to qualify jurors to begin with. So I've got a little bit of time in order for that to occur. The more pressing thing is just depending upon how many defendants we have, will be configuration of 1C. And of course, we'll work on that between now and Wednesday.
And can I ask the court to just kind of put in the back of the court's mind something we've also been thinking about, just logistically, given what we expect to be the length of the trial and potential issues with jurors. The APS case is really the only thing that we have that's kind of similar to look to in terms of logistical issues. And one of the things that we've been discussing, the attorneys have been discussing, are jurors and their hardships and, jury payment and jobs and that sort of thing. So we at some point set aside a little bit of time to have a discussion about maybe some things to consider that might deal with some potential hardships, financial hardships that I know a lot of jurors are going to be addressing. At course, convenience, obviously.
Without putting it out in the ether, I'd rather wait on that just a little bit. Okay, till Wednesday. But yes, I have thought about that, and yes, we'll try and make it so that all who want to serve can serve. But we're kind of bound by their individual circumstances and their answers. So, but in terms of when we start, I do have a little bit more flexibility about what we'll do with payment as well as even taking regularly scheduled breaks. But I like to get through jury selection first.
Sure.
APS, Judge Baxter had a schedule. Yeah. I think the schedule is probably pretty good, but it's also going to be dependent upon things like today, and we've experienced over the last 5-6 days, people getting sick, other things. So, we'll have to build in some time to take a knee and some other things. So, yes, I have thought about those kind of things.
Fair enough.
Okay.
The last thing that I have, Judge, I just want to put on the record, in regards to our discussions, the defensive discussions with the state, we had approached the state in regards to getting complete witness lists with contact information and so forth. That's my understanding from our prosecutor that they intend to get us complete witness lists by tomorrow, the 30th, so that we can. We know that the state has already started subpoenaing witnesses. We'd like to be in a position where we can start making contact as well. We understand that they're going to give us that information by tomorrow. Madam Prosecutor, please correct me if I'm wrong about that. That's what we discussed previously.
Your Honor, that is correct. We have provided a preliminary list when we first told the court that we would. As we have gotten updated information, we intend to provide that information as well to all of the defense counsels.
Okay.
Tomorrow.
Okay.
And then we also ask, of course, that all, to the extent that the state has them in their possession, any reports, inclusive of cell phone reports or investigative reports that we do not have thus far, if we can please go ahead and get those. Just by way of example, Ms. Steele and I have discussed whether we need a cell phone expert ourselves. We don't know that until we kind of know what their report has and whether we'll need one. So, to the extent that the state can get that to us, I wouldn't say instanter, but that's being a bit
Aggressive.
yeah, as soon as possible.
Okay.
Yeah.
Okay.
So that's
All right.
just want to put that on record.
Okay. All right, Madam.
Thank you, Your Honor. We will get that to them as well.
Sure.
And in turn, we have asked whether or not they have any reports of any of their experts. I know that today we were intending to, at some point, address one of theirs. We don't have a report. We don't have clear understanding of exactly what that expert will be, what they'll be attempting to get that expert for. But I've been told that we have that person's resume and 2 articles. That still doesn't answer my question. We would ask for clarity on that. Additionally, Your Honor, there is the issue of addressing bench conferences during the course of the trial. We would like to make certain that the defendants each waive their rights to be present at the bench during the bench conferences to ensure that there are no issues on that subject later down the line.
Okay. Well, okay. Let me deal with it 2 ways. Couple issues. First one is I'll just say you all have a continuing obligation to supplement your discovery pursuant to Title 17. So please go ahead and continue to do that. And as soon as you receive anything that should be turned over, please turn it over so it doesn't cause us any delay in the proceedings. As for bench conferences, we plan on, Ms. Weaver is going to tape those as well, but to the extent that your clients can't be present, is it we can take the roll and see who's left? Is there anybody who would waive their client's presence at those, and we'll just go ahead and tell their clients what we talked about? Ms. Callan? Yeah, do you wish to waive your client's presence for bench conferences? No, I'm not going to. It means he can't come up here.
I understand that, but you weren't present.
Oh, yeah, no. For what we discussed, will you tell him what we discussed? Sure. Okay, that's what I mean waive his presence at my bench for bench conferences, okay? Not his presence in the courtroom, but just for bench conferences. That's fine. Okay, all right.
I don't intend to waive my client's presence for bench conferences. I would ask, I know it might be a pain for the jury, but ways that I've handled it in the past in other circuits is the jury exits and we have a discussion in the courtroom and then the jury comes back once we're done. I don't know if the court might be inclined to utilize that.
Not my first rodeo, Ms. Bernard. That becomes very difficult, though. So, I mean, and jurors from a historical standpoint don't like to be treated like yo-yos. So, just ask you to think about it. You're not required to waive your presence because I can do that. I can summarize it, but it makes things with, 10 to 13 folks, 15 folks remaining, it may be a chore for me to do that. Maybe the easier course of action, but I'm going to need concurrence for that, or else it will be protracted in that respect.
Thank you, Judge, and I'll think about it.
All right.
was.
Sure.
So Judge, one of the things that.
And you are?
I'm sorry, Parks and Rec.
Okay.
Parks and Rec, this on behalf of Mr. Seaweed. So Judge, one of the things that we've done in another circuit is, I don't know what the cost factor is and the time crunch in terms of where we are today versus where we're going to be next week. But one of the things that we're doing in the DeKalb circuit is we're utilizing headsets, and so no one has to remove themselves from.
I've used those before.
So the headsets, just allows everyone to talk to each other and listen to each other without including the defendants and the lawyers, and that is very effective in some trials that I've been involved.
So you buying everybody something this weekend? About money, big money. You gonna roll it out for us? Okay. It is a great suggestion. I thought about it. I just don't have the. We usually do this for folks who are hearing impaired, and my courtroom's not set up for that type of tech. If I can figure it out, I'll be more than happy to, as a suggestion for me to do that. But yeah, I know I'm sure it's effective, and it definitely sounds like it. So, yes.
Your Honor, Sui Chalik, Mr. Dorsey, for purposes of bench conference, I do waive the presence of that session discuss it with him. But if we do have an alternative, like the headset, we'd like to partake in that.
Thank you, sir. Mr. Matthews, I didn't quite. Mr. Matthews, do you want to waive bench conferences if I can't do the wireless?
If I can spend a moment or two to talk to my client and ask them.
Sure. Okay. All right. Okay. Anybody else?
Ready?
Yes. Just discussing that issue. All right, Mr. Mr. Stillwell, okay?
Especially if he's going to be checked.
Anybody else?
Yes, Durante Partridge on behalf of the weekly as well.
Okay, thank you. Next.
Your Honor, Nicole Fagan on behalf of Mr. Bender. We're going to waive, but our one request is that when we do the bench conferences, the entirety of the prosecution's table is not able to also be at the bench, and only the prosecutor that is affected by the witness that is currently.
And what's the justification for that, madam?
It's my client's request as part of his waiver that instead of having the entire team being present, if my client only has one attorney, then his request is that the prosecution is only represented by the attorney questioning that witness.
All right. All right, State, what do you say?
Yeah, this is a waiver, not a negotiation. We ask that the court not require prosecution. There are times when more than one of us is dealing with a particular issue. We are not asking that only one defense attorney is at the bench at a time, so we would certainly ask the court not to limit the state to having one lawyer at the bench during the conferences.
Okay. Well, Ms. Fagan, no waiver for you then. Okay, all right. Ms. D. Williams?
Mr. Ryan, we will not be waiving our presence at this time.
Okay. Ms. Gladden?
We are waived as well, thank you.
Mr. Harvey?
Judge, I can't respond because I would have to talk with Mr. Nichols before I can respond. He is allowed to waive his presence during the trial, but only if he's present and acquiesces when that decision is made. So I'm sorry, I can't respond. I'll do my best to try to tell the court prior to trial, however.
That's fine, sir. That's fine. Ms. Hingerty? Thank you. Mr. Menendez?
Yes, Your Honor, I'm here.
Waive or no waive? As to bench conferences.
I'm in the same position as Mr. Harvey, Your Honor. I would need to speak with Mr. Farley first. And I'm awaiting my COVID test results. I was tested yesterday, but haven't gotten the results back.
Okay, sir. Mr. Johnson?
Yes, Your Honor, we have this individual, we do not waive at this time, and reserve the right to modify our response.
All right, sir, thank you. Mr. Steele?
We are not going to do a blanket waiver, but we will do issue by issue.
Okay, no, that doesn't, it's not, this is bench conferences, okay, so, not for other critical stage Sixth Amendment requirements, so.
Right, well, schedule is bench that's not, doesn't cover, so, talking about issues that are covered by the
Okay, all right. Mr. Hill? Waiver or no waiver?
Can I get just a little bit more time to consult with my client about that, and I'll be sure that you know.
All right, thank you, councils. All right, anyone else, any other ministerial? Madam?
We did not put the last offer.
Haven't out there yet. Okay, all right. Anybody else? Any other defense attorneys have any other administrative issues? Yes, Mr. Johnson.
Yes, Your Honor. As you are aware, there have been numerous individuals who have opted out of these proceedings and taken a plea in this matter. I was just wondering, would it be prudent for the state to provide us with the defense with a summary of the pleas and the information that may be discussed if the testimony is offered for our preparation purposes, because these individuals may be potentially called as witnesses later on in the trial. And I do believe, I know I speak for Mr. Eppinger, that we'd like to know what the substance of these plea offers are prior to the beginning of this trial.
I believe that would be covered under discovery, wouldn't it?
Yes, Your Honor.
Okay, so I think that would be something the state would probably need to disclose to you.
I have not, well, of all the people that have taken pleas thus far, I have not received.
7 of them so far.
I have not received information regarding their offers prior to coming to court and hearing it from other defense counsel, Your Honor.
All right. Ms. Love and Ms. Hilton, is that something you all are going to give or otherwise supplement your discovery?
Your Honor, certainly at the appropriate time, which would be prior to the start of this trial, we will provide a defense counsel, each defense counsel, with any pleas and the terms thereof that have been taken in this case.
Okay.
And the reason I say that, Your Honor, this case has gotten quite a bit of media coverage. I've been able to find out about the plea offers online before I come to court, before hearing about it from the state. So, given the media coverage in this case, as the plea offers are extended, I believe it would be prudent to give those to the defense at the time that they are extended, especially given the fact that they're already on TV and all over the internet as well.
Your Honor, for many reasons, the state does not intend to extend or that information, to disseminate that information prior to it being extended.
And so, yeah, I mean, Mr. Johnson, I certainly understand what the state's saying. I understand what you're saying. There's kind of a gap that goes in between because media does it in real time, and you know, the state, I'm sure, is that's something that's as a part of supplementation they're required to do. So, you know, they know about their responsibilities, and you do as well. So we'll just do the best we can with that. Okay. All right. All right. Anybody else?
Yes, Ron.
You are.
Oh, Jeffery Hill on behalf of the I've discussed it with him a little bit more, and he would like to waive it.
Okay. Thank you, sir. Okay, anybody else? Any other administrative announcements from the defense? Any of the defense attorneys? Okay, all right. State, I'm going to, it is the court's direction that, given that we are going to trial next Wednesday, to sever the following individuals. Mr. Bradford, who was just arraigned and has no counsel. Mr. Fleetwood has no counsel. Mr. Garlington has no counsel. And Mr. McMillan has no counsel. So those 4 individuals I'm going to sever for purposes of trial. They'll have to be tried another time. I am going to work with Mr. Hoover and as well as Ms. Bernard to see if they can't get them lawyers. But we've been attempting to get lawyers for a number of them for several months. So unfortunately, I'm going to have to probably sever those. Any other issue? Any other discussion about any one of those individuals? Bradford, Fleetwood, Garlington, or McMillan? McMillan, I should say.
And Your Honor, obviously we have 2 that are still outstanding.
And those are?
Mr. Cobb and Mr. Winfrey.
Mr. who? I'm sorry?
Justin Cobb.
Cobb?
Yes, Your Honor, and Jimmy Winfrey.
All right. Winfrey, Cobb and Winfrey, I'll sever those two as well, since they have not been amenable to justice as of yet.
And Your Honor,
So that would be 6. Anybody else?
that is all of the ones that we dealt with in that manner. I just wanted to make sure that we were still working, or will continue to work on getting counsel for the ones that.
Yes, and in fact, I'm gonna send out another correspondence. We are trying to work on getting contract counsel as well on the Superior Court side of the house, as well as the efforts of several other entities. Everyone's really working hard on this issue, but as you can see, it's been quite challenging. So, all right. So those particular individuals, once they get attorneys, we'll deal with them at some point in the future. Ms. Bernard?
Yes, Your Honor.
Have those individuals, at least the two, except for the 2, Cobb and Winfrey, have not been arrested as of yet, but have the others at least qualified for your services, and is there a request in for them to have C3 counsel?
Yes, Judge. It's been quite a while, and Bradford, I just got done yesterday. Once I got that, I think it was yesterday when we discussed Bradford.
Yes,
so
ma'am.
that has been sent over yesterday. While I was in court, I did that, and then the others have previously been qualified, and we've been trying to find counsel.
To no avail as of yet, is that correct?
Yes, Judge.
Okay, all right. I know you're working hard on that. Just please keep us posted. And I'm going to get in touch with Mr. Hoover as well, again, and see if he has not gotten any other folks for us on those folks that need C3 counsel.
Yes, Your Honor.
Okay, all right. Okay, so Mr. Fleetwood, where are you? Sir, we're working on getting you counsel, but you will not be going to trial next week, okay? So once we get a lawyer for you, that lawyer will tell you what the next steps are, okay? All right, sir. Mr. Garlington? Raise your hand. Sir, you're in the same position. I'm going to have to, you're not going to come to trial next week, but as soon as we can get you a lawyer, that lawyer will go ahead and advise you on the next steps, okay? It's unlikely that you'll get one before Wednesday. I'm sorry? I don't know. I mean, we've been trying to get you a lawyer for a little bit. If your people get you a lawyer, then please let the state know and let the court know, and we can work out something, okay? But right now, you're not going to trial next week, okay? All right, sir.
Sure, Your Honor. Can I be excused?
In just a minute. Mr. McMillan? Sir, same thing with you. Since you don't have counsel as of yet, I'm not going to require you to go to trial next week. Once we get you a lawyer, that lawyer will advise you on the next steps, okay? All right, thank you, sir. Yes, Ms. Gladden.
Judge, we are still speaking with the state, but this is something I brought up when I first got retained, and I do have something filed in writing. I would be requesting a continuance on behalf of my client if we could not work out something today. As the court knows, the discovery is voluminous in nature, very extensive. Since this is a RICO case, again, all of the evidence against all the clients would go against my client, and I would be prepared to argue that with the court if we're not able to reach a resolution before the end of the court date. I just wanted to mention that.
All right, okay. All right, thank you, madam.
Thank you.
Anybody else? Okay. Debbie Talton? Where is he? Oh, it's okay. That's right. Just hold on a sec. Just hold on a sec. I got you. Okay, hold on one sec. Okay. Other than Mr. Beebe, Mr. Mender, and Mr. Stevens, unless you all have anything else, I'm going to release you. I'm going to tell you one other thing to those particular individuals who were in the courtroom. I know that the state may have offered plea negotiations, but plea negotiations go both ways. So if you're represented by counsel, there's nothing wrong with your attorney approaching the state to seek a plea agreement. 95% of all criminal cases are resolved that way, and that is something that you can certainly think about. You're not required to do so, but I don't want you to think that if you were not offered a plea negotiation that by the state, that is not something open to you. So if you fall in that particular category, please talk with your lawyer and see what you can see what he or she best advises you on doing. Okay. All right. Unless there's anything else. Oh, one more thing. State, I need another copy of the indictment that reflects our most recent discussion. So if you could get with the defense and print me a copy this afternoon, because on Tuesday I'm going to record the indictment and the script for Wednesday. I'm going to do that Tuesday afternoon with FGTV. So, lawyers, on Tuesday I will record the indictment and I will record the script. So Wednesday, when the people come in, our jurors come in for us to consider hardships and fill out their questionnaires. That's what the big lift will be Wednesday, Thursday, and Friday. And then depending upon who's left, we will start examination in panels on the 9th. So that's the goal at this point in time. So anybody else have anything else for the time being? Yes, but that doesn't include you. So, so the rest of you can be excused. Okay, all right. Okay, hold Mr. Beebe, Mr. Mender, Mr. Stevens. Mr. Matthews, let me see the bench a second. I know you had to, you can remain seated, that's fine, you don't need to stand up. I know when you stepped out to take care of your medical issue, Ms. Hilton was gonna say that there was an offer extended to your client, so she has not put that on the record for purposes of posterities, but she's ready to do that this time, okay?
We're ready, Michael.
All right.
Ready, Your Honor?
Yes, ma'am, go right ahead.
Your Honor, as it relates to Mr. Tanquarius Mender, Mr. Mender is charged with count 1 of the indictment, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, which carries a sentence of 5 to 20 years. He's also charged with count 44 of the indictment, which is possession of a weapon by an incarcerated individual, which carries a sentence of 1 to 5 years. Count 45, possession of a telecommunication device by an incarcerated individual, which carries a sentence of 1 to 5 years. And last, count 46, which is participation in criminal street gang activity, which carries a sentence of 5 to 20 years. Mr. Mender is an ANC recidivist. The state did file a recidivist notice on December 9th of this year. If Mr. Mender was found guilty of all the counts in the indictment, he'd be looking at a maximum exposure of 50 years to serve in prison.
And now, could you explain the difference, I think, for Ms. I'm sure that Ms. Fagan has probably explained that to her client, but can you tell for the benefit of the record and for Mr. Mender's benefit, what potentially may happen if he were to be convicted of any of these particular counts? Like what would, under A or C?
Yes, if he's convicted of any of the counts, as an ANC recidivist, Mr. Mender, you would have to get the maximum amount on for that charge, and then whatever time the court gives you, which if it was to be the maximum, you have to spend every day door to door, which means you have to spend every day in custody.
You get no good time.
No.
It's a to-the-door sentence.
Yes, he would get any credit for a time served.
Of course, yeah, absolutely.
But anything else would be a full sentence door to door.
So his max is 50 years?
Yes, Your Honor.
Okay, and what's the state's offer?
Yes, Your Honor. The state's offer for Mr. Mender as to count 1 is 16 years to serve 1 year, commuted to time served, with a balance of 15 years on probation. The state would offer that his probation could be terminated upon successful completion of the first 10 years of this sentence, provided that he violated no provisions of the agreement or no special conditions of the agreement, and that he violates no law of the state of Georgia. As to count 44, the state's recommendation is 5 years to serve 1 year, commuted to time served, with a balance to be served on probation, concurrent with count 1. As to count 45, it would be 5 years to serve 1 year, commuted to time served in confinement, commuted to time served, followed by 4 years on probation, concurrent with counts 1 and 44. And count 46 would be 16 years to serve 1 year, commuted to time served, followed by 15 years on probation, concurrent with count 1, 44, and 45. Would be the offer. Mr. Mender also is currently on another indictment, 21 SC 178250. And this case, as a part of the agreement, would run concurrent with that case whenever he resolved that other case, Your Honor.
Is that before me or before another division?
It is in this division currently, Your Honor. And that's being handled by ADA Lauren Jansen with the state.
Does he have bond on that case ending in 250?
I don't believe he has a bond on that case. No, he has a no bond status.
But on this case, he could go home today.
Correct. If he was given a bond, he would. This case, he would not have served any jail time on this case.
Okay.
And that offer will also conclude today, Your Honor.
All right. Ms. Fagan, have you communicated that to your client in terms of is that to correctly summarize the plea agreement or the potential plea offer, I should say?
The only change was that he wasn't aware of the concurrent status for the second case. At this time, time, though, he still maintains a not guilty plea.
Sure.
Respectfully requests, rejects the offer, and we announce ready for trial.
Okay, Mr. Mender, I'll tell you and I'll tell Mr. Beebe and Mr. Stevens the same thing, okay? At this point, you have the absolute right to plead not guilty, and that's what the law will presume, and the court will, of course, instruct that you have a presumption, as the presumptions and protections you enjoy as a criminal accused. You have to decide for yourselves what you want to do in this particular case, depending upon the results or the outcome of the trial. The only thing I would tell you, Mr. Mender, is the most, and I'm sure that Ms. Fagan, she is a very fine attorney. Seen her work. But trials, there's one thing about trials, it's uncertainty. You don't know what's going to happen. So you got to beat 4 counts. If you don't beat them, what will happen is, under this A&C recidivist statute, I have to, under the law, sentence you to the maximum sentence. And then whatever I sentence you to, you serve to the door. That's not anything I have any discretion over. It's not anything because I don't like you or because of what you're being charged with or whatever. Those have nothing to do with anything. That's what the state of Georgia, the legislature has mandated that I sentence you to. So one of the things a plea does is you know what you're getting. It caps your exposure. So, and what the state's telling you today is if you take the plea today, this is what you're going to get, and this is what I probably sentence you to, and you're done. You got to decide that for yourself. You can't be worried about any of these other folks that are attached to this indictment, because a plea is individual to that particular person for those particular reasons that he or she feels is of best interest to them, not anybody else. So if you want a couple minutes out to talk with Ms. Fagan about that, nobody will be the wiser, and certainly, but if you don't wish to do so, that's fine too. You'll get the fairest trial that the law demands and expects you to get. You will get that. I, as your trial judge, will make sure that that occurs. But one of the things I cannot do is I can't force the state at the end of trial to pull this recidivist notice. If you get convicted, they can maintain it, and you'll serve every day of it. And Ms. Fagan can ask them to pull it, and they can say no. I can't make them do that. So you got a lot to think about. So I'll give you a few more minutes to ponder that, because that is, when they file a recidivist notice, that is, that they have basically, in poker terms, they've called. Like, what do you want to do? So I'll let you think about that, and you can let me know, and if not, then we'll see you next week for trial. Mr. Beebe, where are you?
Here, Your Honor. Because we're in a similar situation, we would reject the state's offer as provided on record, Your Honor. However, Mr. Beebe would ask the court if the court would hear a non-negotiated plea as to the indictment.
I would.
If not, Judge, Mr. Beebe was then asked if he does not agree with Your Honor's sentence, would the court allow him to withdraw the plea and proceed to trial?
I need to think about that for just a second, okay?
Understood.
Just give me a minute, okay? But yes, that's more than fine. Mr. Beebe, you got the same kind of same discussion I had with Mr. Mr. Mender applies to you, but let me just get back with you just a second, okay? Mr. Stevens, where are you? Okay, madam, are you still talking with your client?
Yes, Your Honor, I'm actually still exchanging text messages with the state.
Okay, I'm going to take a couple of minutes out and let you all continue to chat. I'm going to just take a recess, and I'll come back in just a minute, okay?
Thank you, Your Honor.
Okay, you're very welcome. All right. Good afternoon, counsel. Answer part from here on the record. Versus Trontavia Stevens in indictment 22 SC 183572. Good evening, Ms. Gladden, and good evening, Mr. Stevens.
Good evening, Your Honor.
Good evening. And good evening, Ms. Love, and good evening, Ms. Hilton.
Good evening, Your
All
Honor.
right. Mr. Stevens, can I get you to raise your right hand the best you're able, please? Do you solemnly swear or affirm the evidence you shall give in the matter now in hearing shall be the truth, the whole truth, nothing but the truth, so help you God, or so firm?
I do.
All right, you need to speak up, sir.
I do.
Okay, all right. Put your hand down. All right, Mr. Stevens, over the next several minutes, I'm sure Ms. Gladden has probably told you, we're going to go through what's called a providency inquiry. Half of it is what we call your Boykin rights. That means those are constitutional rights that every criminal accused enjoys, meaning because in our system of jurisprudence, we don't force people to plead guilty. So courts have to make sure you understand your rights and you give those up freely and voluntarily before I can sentence you, okay? So that's the first part. The second part of the inquiry, the state has to lay out a factual basis as to what they would have been able to prove at trial beyond a reasonable doubt. So assuming that they can, those two things, they pass, then I can determine that your plea is provident and accept your negotiated plea, okay? You gotta answer
yes, sir.
Yes or no for the record. Okay, all right. So, Ms. Love, is it gonna be you, Ms. Love?
It's going to be Ms.
Okay.
Hilton.
Ms. Hilton is going to ask you a series of questions that's designed to get at the two areas we talked about. When she's done, your attorney, Ms. Gladden, will offer me some things on your behalf, and then you and I will have a short conversation, and I should be able to accept your plea, okay?
Yes.
Okay, wonderful. All right, madam, go right ahead.
Thank you. May I take off my mask?
You can, yes, ma'am.
Thank you. Mr. Stevens, if you could please state your true and correct legal name.
Trontavia Stevens.
And are you the same person referred to as Trontavia Stevens, also known as Tick and also known as Slug, on indictment 22 SC 183572?
Yes.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you?
29.
And how far have you gone in school?
I got a GED.
Okay. Are you able to read, write, and understand the English language?
Yes.
Do you understand that you are charged in this indictment with count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your lawyer, your attorney Gladden, about all the facts and circumstances known to you regarding the charge in this indictment?
Yes.
Have you also been able to speak with her about any potential defenses?
Yes.
Do you need any more time to discuss this matter with your attorney?
No.
Are you satisfied with her counsel and representation?
Yes.
Do you waive formal reading of the indictment?
Excuse me?
So waived.
Yes. I asked if you and your attorney waive formal reading of the indictment.
That means they don't want to read the charge.
If not, I got to read the indictment.
Oh. So waived.
Okay?
Yes.
All right.
Do you waive any and all defects, if any, with respect to the indictment?
Yes.
Mr. Stevens, have you been arrested on these charges?
You've been arrested on these charges.
Yes.
Okay. And Your Honor, the state is unaware of any outstanding warrants related to these charges. Ms. Gladden, do you know, are you aware of any outstanding warrants as it relates to these charges?
I'm not.
Okay. Has your attorney advised you of the minimum and maximum sentence for the charge in which you are pleading to?
Yes.
Do you understand that as to count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, that it carries a minimum of 5 years and a maximum of 20 years in custody?
Yes.
Do you understand this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence that I will read, but the court does not have to accept this recommendation, and that the court can sentence you to the maximum on each charge?
Yes.
Do you understand that?
Yes.
Do you understand that this plea, the state's offer on this plea is, as to count 1, 10 years to serve 2 years, commute to time served with a balance of 8 years on probation? Do you understand that?
Yes.
Do you understand that there are certain special conditions as it relates to this negotiation?
Yes.
For 1, you shall abide in full by each and all of the terms of this negotiated agreement, and your failure to abide by any of the terms of the agreement shall constitute a violation of this agreement. Do you understand that?
Yes.
Do you understand that you shall testify truthfully about all matters relating to this case upon which you are questioned at any trial or judicial proceeding stemming from the facts alleged in this indictment?
Yes.
Do you understand that in accordance with testifying truthfully about all matters related to this case, you acknowledge that each and all the statements contained within the defendant's factual acknowledgments portion of this agreement are true, and that you will testify truthfully about those statements and any matters related to this case when asked to do so?
Yes.
Do you understand as a special condition, you shall possess no guns unless your right to do so is restored?
Yes.
That you shall also submit to random drug screens by the Department of Community Supervision and any agency designated by this court?
Yes.
That you shall commit no criminal acts?
Yes.
And that you will relinquish any Fifth Amendment right related to any statement contained within the defendant's factual acknowledgments contained within this plea agreement, and you will make no attempt at trial to assert a Fifth Amendment privilege when questioned on these matters. Do you understand that?
Yes.
Do you understand that some of the factual acknowledgments that you acknowledge is, one, that Young Slime Life, aka YSL, is an organization made up of 3 or more members or associates who share common identifiers that include but are not limited to colors, hand signals, and terminology, who have committed crimes intended to increase the notoriety, street credibility, and reputation of YSL. Is that one of your acknowledgments?
Yes.
Do you also acknowledge that you were one of the founding members of Young Slime Life?
Yes.
Do you also acknowledge that you committed an aggravated assault as alleged in count 1 of this indictment by brandishing a gun at an undercover police officer that was surveilling a vehicle that was hijacked from a woman?
Yes.
Do you acknowledge that in October of 2014, you were arrested with a red bandana and you were observed with a YSL tattoo and a Cleveland Avenue Rock Crew tattoo amongst other tattoos?
Yes.
Do you also acknowledge in that same incident when you were asked by law enforcement about your Rock Crew and your YSL tattoos, that you truthfully advised law enforcement that you were a member of a gang called Rock Crew, but that group is no longer going by that name and now goes by YSL, which originally stood for Young Slime Life?
Yes.
Did you also in that same conversation advise law enforcement that YSL originally stood for Young Slime Life, but the group began calling itself Young Successful Lifestyle after Jeffery Williams, aka Young Thug, signed a record deal?
Yes.
Do you also acknowledge that the statements made to police about Rock Crew and YSL, as reflected in sections 3 and 4 above, which I just mentioned, are true and accurate?
Yes.
You acknowledge that you've been accused of and arrested for robbing women?
Yes.
You acknowledge that you are the same person referred to as Tick in the song by Young Thug entitled You, in the verse, She Getting Robbed by Tick?
Yes.
You also acknowledge that on February 4th, 2021, you participated in a group chat with fellow YSL founder Jeffery Williams, aka Young Thug, and YSL associates Wooney Lee, aka Slime Life Shorty, wherein Jeffery Williams stated, "YSL rule the world, kid. Y'all just start bringing me the money. Man, y'all stop playing with me." Do you acknowledge that?
Yes.
Do you acknowledge that on May 13, 2021, you participated in another group chat with fellow YSL founder Jeffery Williams, aka Young Thug, and YSL associates Martinez Arnold, Miles Farley, Quantavious Greer, Antonio Sumlin, Wooney Lee, wherein Jeffery Williams asked, "Y'all ain't beat him up or shot him yet?" Then states, "Y'all getting soft."
Yes.
Do you acknowledge that the gas station at 151 Cleveland Avenue is a location where YSL associates sell drugs?
Yes.
That also the gas station at 221 Cleveland Avenue is a location where YSL associates sell drugs?
Yes.
And also, do you acknowledge that you cannot truthfully assert that anyone charged in this indictment is not guilty of the crimes as alleged in this indictment, and you will not make any attempt at trial, prior to trial, or after trial to exonerate or exculpate anyone charged in this indictment of the crimes alleged in this indictment, nor will you claim that anyone on this indictment is not guilty of the crimes as charged in this indictment?
Yes.
Do you also acknowledge that if you violate the plea agreement, the district attorney can and will use a statement during any judicial proceeding?
Yes.
You also understand and acknowledge that if you violate any portion of this plea agreement before, during, or after the initial trial of this case, you are subject to having the entirety of your sentence revoked.
Yes.
And you could be sentenced to prison.
Yes.
Do you also understand if you violate any terms of this plea agreement, it will result in your sentence being revoked, and the district attorney will recommend that you serve up to the maximum sentence allowed by law in the Georgia Department of Corrections?
Yes.
Do you also understand fully that if prior to the conclusion of the initial trial of this case, that you fail or refuse to testify to any fact that you now acknowledge in this plea agreement, such failure or refusal constitutes a violation of this plea agreement, and you'll be subject to being sentenced to serve the remainder of your sentence confined within the Georgia Department of Corrections?
Yes.
Do you also acknowledge that no promises, agreements, or conditions have been made other than those set forth in this document, and none will be entered into unless memorialized in writing and signed by all parties?
Yes.
And did you, along with your attorney, sign this document and dated today's date, December 29, 2022?
Yes.
And that's your signature here?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes.
Do you understand if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
What on it?
By law, they have to say that your probation or
Why
parole
that ain't in the paper though?
That's abortion rights. That's just.
I ain't read it. Can you repeat that?
Sure. I'm letting you know your rights. That's not something that's going to. I can't tell you that's something that's not going to happen. That's not something that we're asking for the court to do. But that's something that's a right that I have to read to you.
All right.
All right.
The constitutional rights. Yes. Sorry.
So I'm reading your rights now. I'm going back to reading your rights that you're giving up by entering into a plea. Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes.
For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand that?
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand if you went to trial, that you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? And after each right, I'm going to ask you to say yes or no if you understand, okay? You understand that you're giving up the right to a trial by jury,
Yes.
the right to remain silent and not incriminate yourself,
Yes.
the right to confront witnesses against you,
Yes.
the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case,
Yes.
the right to the presumption of innocence,
Yes.
the right to testify on your own behalf and to present other evidence,
Yes.
the right to subpoena witnesses and compel the production of evidence,
Yes.
the right to have the charges against you proved beyond a reasonable doubt,
Yes.
the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threaten, or promise you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes.
With respect to indictment 22 SC 183-572, where you're charged with one count of conspiracy to violate the Racketeer Influence and Corrupt Organization Act, how do you plead?
Guilty.
Is this guilty plea freely and voluntarily given with a full knowledge of the charges against you?
Yes.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have 4 years from today's date for the felony charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
And Your Honor, if this case were to go to trial, the state would expect to prove that the organization YSL is an enterprise, that this defendant is a part of that enterprise along with his other co-defendants, and together on or between the 24th day of January 2013 and the 8th day of May 2022, they did unlawfully conspire to acquire, maintain, directly and indirectly, an interest in and control of United States currency and other personal property through a pattern of racketeering activity, and also while associated with an enterprise, did unlawfully conspire to conduct and participate in, directly and indirectly, such enterprise through a pattern of racketeering activity. That the associates of the enterprise Young Slime Life, also known as YSL, that they did conspire to associate together with others for the common purpose of illegally obtaining money and property through a pattern of racketeering activity and conducting and participating in the enterprise through a pattern of racketeering activity. And in furtherance of the conspiracy, the defendants engaged in certain activities which are enumerated. Some of those activities include preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity, including murder, assault, and threats of violence. Preserving, protecting, and enhancing the reputation, power, and territory of the enterprise by the posting of messages, images, videos, and songs demonstrating an allegiance to the enterprise and a willingness to engage in violence on its behalf. That maintaining armed individuals ready and willing to preserve, protect, enhance the reputation, power, and territory of the enterprise through the use of violence, and obtaining money, weapons, and other property through acts of racketeering activity, including robbery, theft, and the unlawful sale and distribution of drugs. The state will also prove that YSL is a criminal street gang that started in the late 2012 in the Cleveland Avenue area of Atlanta, Georgia, that some of the founders were Jeffery Williams, also known as Young Thug, also known as Slime, Walter Murphy, also known as DK, and this defendant, Trontavia Stevens, also known as Tick, and also known as Slug. That YSL uses a variety of identifiers, including colors, clothing, tattoos, and hand signs, as well as verbal and written identifiers. And we would show that this defendant had a tacit understanding of the enterprise and furthered the enterprise's goals with several acts. Some of those acts are from January of 2013. This defendant, in which he pled guilty, was accused of aggravated assault, in which on that day, an officer with the APD Police Department was working in an undercover capacity. That officer was at an apartment complex in the Cleveland Avenue area doing surveillance on a vehicle that had been hijacked by another YSL associate. While operating in that undercover capacity, Mr. Stevens came out of the apartment along with that other YSL associate and brandished his handgun at that officer. Next, we have another act, Your Honor, where Mr. Stevens has a picture of himself on social media. He has several pictures on social media. Some of those captions on the video, on the images, identify YSL by using the term slime shit, and actually tags Mr. Stevens with one of his former Instagram handles as original slime _ slug. Also in January 2015, he is He has a drug incident that comes from 1813 Sylvan Road, in which he was found with narcotics in the vehicle. Also, in one of the counts in our indictment, Your Honor, he was in a car off of Cleveland Avenue, which is in the YSL Stronghold. He was in that car with a co-defendant on this indictment, Shannon Jackson, also known as Shannon Stillwell. While in the car, officers smelled the odor of marijuana. Upon the search of the vehicle, they found marijuana and a gun. At the time of finding both the gun, both him as well as Mr. Jackson were both convicted felons, and they were then charged accordingly. Your Honor, as you heard within the factual acknowledgement, he's also been engaged in conversations with other members of this indictment. We won't go back over what was said, but you also heard that through the factual acknowledgement in this case. So, Your Honor, based upon that factual synopsis and Mr. Stevens' affiliation, we will ask that the court accept his plea. Also, we would like to tender Stacey's 1 TS into evidence.
One which?
TS.
1 TF? Any objection, Ms. Gladden?
No, Your Honor.
All right, states 1 TF is admitted. Ms.
CS, Your Honor, S as in Stevens.
CS?
T as in Trontavious, S as in Stevens.
Okay. All right. Any objection, madam?
No, Your Honor.
All right, it's admitted for purpose of plea. Ms. Hilton, those facts that you elucidated for the court, those are facts that the state would have proven had the case gone to trial beyond a reasonable doubt as it pertains to Mr. Stevens?
Yes, Your Honor.
Okay, all right. Ms. Gladden, again, good evening, madam. Anything you want to present on Mr. Stevens' behalf?
Just briefly, Your Honor.
Go ahead.
Judge, I just wanted to point out, as the court, of course, can ascertain by the fact that he was only charged in the RICO counts. He's not involved and hasn't been charged separately in any criminal activity regarding this case. It has been alleged against some other co-defendants. He had a string of issues in 2011, 12, 13. He went to prison in 2015 and has been out since the end of 2018, and since then he's been a model parolee. He's passed all of his urine screens. He's not gotten in any more trouble. In fact, they put a parole hold on him, but when they found out that this was mostly based on old crimes and a few posts that were innocuous and some pictures, they did remove the parole hold. So I'm asking the court to accept the state's recommendation, and I just wanted to point out that he's tried to be a good citizen and do what he's supposed to do since he's been out of prison, Your Honor. Thank you.
All right. Mr. Stevens, good evening, sir.
Good evening.
Sir, do you have the opportunity to fully discuss the facts and circumstances of this case with your attorney, Ms. Gladden, to your satisfaction?
Yes, Your Honor.
Did she explain to you the various constitutional rights you give up by pleading guilty to your satisfaction?
Yes, Your Honor.
Those are the same rights that my prosecutor, Ms. Hilton, just set forth on the record a few minutes ago. Do you have any questions about those rights you wish to ask me?
No, Your Honor.
All right. I am holding the indictment in this case, okay? And on page 6 of the indictment, I'm going to show you. Is this your signature on the page of this indictment above the word defendant?
Yes, sir.
All right. Before signing this indictment, did you have the opportunity to fully discuss the facts and circumstances of this indictment with your attorney, Ms. Gladden, to your satisfaction?
Yes.
Yes?
Yes.
Yeah.
Do you need more time to discuss it with her?
No.
Okay. All right. But before you signed it, you had an opportunity to talk with her.
Yeah.
And you don't want to talk with her about the indictment anymore?
No.
Okay, all right. I'll note the indictment's been signed and the plea has been entered. Mr. Stevens, based upon the responses that you've given during the court's inquiry, I find that your guilty plea is freely and voluntarily entered. I find a factual basis for your plea. I'm going to accept your plea as tendered and as negotiated. To count 1, conspiracy to violate the Racketeering Influence and Corrupt Organizations Act, the court will sentence you to 10 years to serve 2 years. I'll commute that to the time you already served, with a balance of 8 years on probation, subject to the special conditions that have already been set forth on the record. I'll go through those with you right now. But is that your understanding as to the base sentence?
Yes, sir.
All right. So you shall abide by each and every condition of the negotiated agreement. That's the one that you signed and Ms. Gladden signed along with the state's counsel. Remember that one?
Yes, sir.
All right, that states SC1 as it pertains to you.
Yes, sir.
Okay? All right. You shall testify truthfully about all matters relating to this case upon which you are questioned in any trial or judicial proceeding stemming from the facts alleged in the indictment. You agree to do that, right?
Yes, sir.
Okay. In accordance with testifying truthfully about the statements contained within the defendant's factual acknowledgments, which was already read into the record, are true, you shall testify about those statements in any matters related to the case when you're asked to do so.
Yes, sir.
Okay. You'll possess no guns unless your right to do so is restored, is that right?
Yes, sir.
You shall submit to random screens as required by the Department of Community Supervision and any agency designated by this court, is that right?
Yes, sir.
You shall commit no criminal acts.
Yes, sir.
All right, and also you'll be subject to a curfew from 10 p.m. to 6 a.m. unless you're otherwise working, in school, or an emergency situation arises. How old are you, sir?
29.
29?
Yes, sir.
You have any children?
Yes, sir.
How many children do you have?
3.
How old are they?
11 and 2 7-year-olds.
Okay, so let's say, for example, your 7-year-old gets sick, or your, is it 12-year-old or 10-year-old?
11.
11-year-old gets sick, and it's 2 o'clock in the morning. You need to take them to a doc in a box or some of the emergency room. That wouldn't violate your probation, okay?
Right.
Or you need to go pick up your mother at the airport in Hartsfield at very early in the morning. That wouldn't violate your probation, okay?
Right.
But if you're out someplace where you're not supposed to be, like a strip club, past this particular point in time, at 10 o'clock in the evening, you'll have some problems. You'll be coming back to see me. You should be at home anyways. It's a statistical probability that it's less likely that crime will find you or you will be involved in criminality if you're at home between the hours of 11 and 4 in the morning. Okay, unfortunately, those are the times that we have a lot of things that go on within our city that it's not a guarantee, but it'll lessen your being involved in that for your family's sake and for your sake. Okay?
Yes, sir.
All right. And you can't have any contact with anybody else in this indictment until these proceedings are over.
Yes, sir.
And what I mean by that is until the appellate procedure in this particular case is over, if any. Do you understand that?
Yes, sir.
Okay. Do you have any questions about my sentence?
No, sir.
Ms. Gladden or Ms. Hilton, any clarifications on the court's entry of sentence or defendant's entry of plea?
No, from the state, Your Honor.
Nothing from defense, Your Honor.
All right, then that'll be the sentence of the court. Mr. Stevens, good luck to you, okay?
Thank you.
All right, thank you, sir. All right, we're in recess on this matter? Okay.
What's your address that I would?
Edward?
2915.
212915. Okay, and your penny. Yes, well, how sweet. Thank you. Yes.
So vendors please done, right? Vendors please.
Me too.
Did any of these guys get presented?
And Your Honor, it was good to see you.
Always a pleasure. Good to see you, okay?
Absolutely, Judge. I hope you feel better.
Much better. You.
Oh, yeah. I will text Jessica or Steve. Yes, please do. Absolutely. You know, it's like sorry. You good to see you. Yeah, it's good to see you too.
Missed the side?
Nice to see you.
I'm glad we got it working. Yeah, we appreciate it. Yes.
We do it.
That crazy. That was just the last minute.
Thank you. Our courage. We'll see you. Happy New Year. We'll see you.
Happy New Year.
Okay?
Yes, sir.
You saw that email, right?
Okay.
I sent an email. Your copy now.
Okay, thank you.
But no. Sorry? Yeah.